Government.
Well, good afternoon, everyone, and welcome to the Heritage Foundation and to the Joseph Story Distinguished Lecture, which is always my favorite event of the year. So as you heard, I'm John Malcolm. I'm the Vice President here at the Institute for Constitutional Government. This lecture has been named in honor of one of our country's most eminent judicial and legal scholars, a man who distinguished himself in many different ways. Joseph Story was involved in politics and civic activities in his native state of Massachusetts. After several years in private practice, he served in the Massachusetts state legislature, serving part of that time as Speaker of the House, and then in the United States Congress. Pretty remarkable when you consider that he did all of that before being confirmed as an Associate Justice on the U.S. Supreme Court at the age of 32, the youngest justice in this nation's history. In addition to serving with distinction on the High Court for 33 years, Story was instrumental in establishing the Harvard Law School, where he served as its Dane Professor of Law. Story was also an accomplished writer whose articles and books were praised on both sides of the Atlantic. His most famous work was his commentaries on the Constitution, which demonstrated his commitment to faithfully interpreting the Constitution as it was understood by those who wrote it and ratified it. The influence of Story's commentaries continues to be felt today among the judiciary and constitutional scholars. We are fortunate to have with us this evening Judge Andrew Oldham as this year's Story lecturer. Judge Oldham has served with distinction on the U.S. Court of Appeals for the Fifth Circuit since 2018, and he had a pretty distinguished career prior to that. After obtaining a Master's of Philosophy from Cambridge University and his law degree from Harvard Law School, Judge Oldham clerked for Judge David Sentel on the D.C. Circuit, and then for Justice Samuel Alito on the United States Supreme Court. He also served at the Office of Legal Counsel at the Department of Justice and also as an appellate lawyer in private practice here in Washington, D.C., before moving to Texas. In the Lone Star State, Judge Oldham served as Deputy Solicitor General, where he argued in courts around the country, including arguing twice before the Supreme Court. And he also served as General Counsel to Governor Greg Abbott, advising him on a whole range of issues. His talk tonight will be on Precedent as scatterplot. Please join me in welcoming Judge Andrew Oldham.
Oh, good evening, everyone. It is an honor to deliver this year's Story lecture. For one, it is exciting to stand at the same podium that my beloved Justice Alito once graced. But for two, I'm very excited to pay homage to Justice Story. Joseph Story, of course, is one of our all-time greats, as John just mentioned. And his life in the law provided innumerable inspirations for a lecture like this one. But the one that I chose to discuss with you this evening is perhaps unorthodox and unprecedented in this lecture series. I'm going to start with his 1842 opinion for the Supreme Court in Swift versus Tyson. Now, I say the choice is unorthodox because out of Justice Story's many accomplishments, Swift generally does not make the leaderboard. If you remember anything about Swift versus Tyson from law school, you probably recall that Oliver Wendell Holmes famously derided it for treating the law as a brooding omnipresence in the sky. And you probably recall that the Supreme Court unceremoniously overturned it in the landmark decision of Erie versus Tompkins. Erie went on to be canonized. It is cited hundreds of times in federal courts across the country every week. And it is the governing gospel for diversity cases in federal court. Meanwhile, Justice Story's Swift versus Thompson has been forgotten and discarded in the dustbin of history. So why would I choose, in a lecture named to honor Justice Story, to talk about arguably his greatest failure? Well, the answer is because it was not a failure at all. To the contrary, Justice Story was quite right. You can mock it as a brooding omnipresence if you want, but law really is a series of doctrinal constellations. Or perhaps the better metaphor, and the one I'm going to use it tonight, is a scatterplot. That is, each individual decision rendered by a court is a data point, and the judge's job is to find the law. Think of it as the line of best fit, or a trend line, through the scatterplot of precedent. This theory of finding law is deeply rooted in Swift and in the general law that defined our nation's founding. But it is deeply inconsistent with the way that judges think about precedent and horizontal stare decisis in federal appellate courts. The prevailing view among my colleagues is that each panel makes law rather than finds it. How so, you might ask? Well, as we say so often that it is hackneyed, the ruling of one panel binds all future panels unless and until it is overturned by the en banc court or the Supreme Court. You could probably all do that with me if we did a sing-along. In the Fifth Circuit, we call this the rule of orderliness. And at my last count, we have 724 cases in the Fifth Circuit discussing this ironclad binding rule. Other intermediate appellate courts across the country have different names for this rule, but they obey it just as often and invoke it just as often. And here is how it cashes out in our appellate courts every day. If a word or a sentence appears in the Federal Reporter, it is as binding on a future panel as the words that appear in the United States Code. Both books, after all, contain rules that have been made by lawful authorities in lawful way. At least that's the prevailing wisdom. This prevailing modern view is deeply inconsistent with Swift. It is deeply inconsistent with the general law. It is deeply inconsistent with the federal judicial function, which is to find the law in a scatterplot. Now, I know it is incredibly perilous to talk about math in a room full of lawyers, but I promise you we are not going to go beyond 10th grade pre-calc tonight. And I also promise you I'm going to show you a slide, but just one, okay? Just one slide, that's my promise. So here is a scatterplot, okay? This scatterplot reflects a particular legal doctrine. So let's say it's the tort of battery. The x-axis reflects time, and the y-axis reflects different plaintiffs, different sets of facts, different cases. And over time, there's lots of different judgments. Each one of those data points is its own particular case for, against a different plaintiff. And so over time, you can see a trend line. In statistics, we would call this a least squares regression line. In high school, you might have called it a line of best fit. But the idea is that that line is the law. That line is the legal rule. It connects judgments over time to show how the law in this particular area applies to different facts and different legal arguments. Now, as you can see, this particular legal line has become slightly more plaintiff-friendly, perhaps, over time. It's changed a little bit. If this were a scatterplot, for example, for the Bivens doctrine, it would look very different, right? There would be a handful of cases in the 70s and 80s, and then it would drop precipitously to zero. But in any event, the flatter the line, the more stable the doctrine. The tighter the line that fits to the scatterplot, the more predictable the legal rule. Now, as with all regression lines, if you remember anything from high school math, this regression line does not touch every judgment. There are always outliers. These outliers, by the way, they're still valid judgments, right? They still bind the particular parties to those particular cases, but they do not accurately or precisely reflect the legal rule. Perhaps they reflect the maxim that bad facts make bad law. Maybe they reflect the maxim that bad judges make bad law. But either way, extreme outlier judgments are bad evidence of the legal rule, that is, of the trend line, because the trend line is down here and the bad outlier judgments are way up or way down there. So what do I do when I get a new case? Well, I look out over the entirety of the doctrine, starting at the very beginning, and I work my way to the present, and I find the trend line. That is, I look for the legal rule that runs through the bulk of a densely clustered set of legal data points. And then I figure out whether my particular plaintiff is above or below that line, and then I write an opinion to explain why I put my new data point where I put it on the scatterplot. Now, should it matter if the facts of my case, the ones that's before me in a new case, are eerily similar to the facts in one of the outlier data points? Justice Story would say absolutely not. The rule that governs my case, all cases, is the trend line. That's the legal rule, not the facts or law in an outlier data point. The outlier data point doesn't bind me as a judge. It doesn't bind a party to a future case. What binds us is the trend line. So if I blindly follow the outlier judgment, I risk both misidentifying the law and extending the error. Now, speaking of things that do not bind people, the opinion I write to explain my judgment binds no one. It does not bind the parties. It does not bind the future. It merely explains how I came up with the legal rule, how I reach my judgment for or against a particular plaintiff. If I write the opinion well, maybe it helps future judges find the law. But the only thing I'm doing of any real legal significance is announcing a judgment for or against the parties. Now, for many, or dare I say most, intermediate appellate judges, what I just said is a sin worthy of excommunication. The panel opinion is not binding, they might ask with sheer horror and incredulity. What of the rule of orderliness that requires us to take every jot and tittle and footnote in every published opinion and religiously apply them as if Moses had brought them down from Mount Sinai? Panels make rules, don't they? Just like Congress makes statutes. That's why we publish both of them in leather-bound books. And it's why we call our opinions case law. What heresy is this scatterplot in least squares nonsense that would take from us the binding panel opinion? Well, before anyone threatens to throw me in the water to see if I sink, let me just tell you that this precedent as a scatterplot theory is a shorthand for how judges have operated for centuries, finding and then applying pre-existing law. It is, in other words, a heuristic for the way that Justice Story perceived the general law in Swift versus Tyson. As Professor Caleb Delson has described it, the general law consists of rules whose content is not dictated entirely by any single decision maker. It instead emerges from patterns in many different jurisdictions. In other words, general law is exogenous to any single judicial opinion. It emerges from a pattern of decisions, each of which is just evidence of the underlying law. So with some hard work, the judge can analyze the pattern, find the line of best fit, and hence find the law. Now, as with all good legal stories, or virtually all, this one starts in England. At the dawn of the 16th century, English courts began to transition from a system where juries were responsible for finding both the facts and the law to the system that's more common and more understandable to lawyers of today, where juries found facts and then judges would apply the legal principles to those facts. And thus was born the idea that judges would survey the law and find the relevant legal rule. This approach to precedent became particularly important in courts at equity. For example, in the middle of the 18th century, the Lord High Chancellor and First Earl of Hardwicke found a legal rule by stating, quote, "It has been determined in so many circumstances that I am bound by the decisions." For Lord Hardwicke, the idea was that a body of judgments could clarify or crystallize a rule in the case before him. Once enough judgments came out the same way, on the same facts, the law became clear. And once a number of legal judgments makes the trend line or the law clear, then parties can rely on them in ordering their private affairs. Precedent, in other words, is not one decision. It is the collective wisdom of many decisions fitting on a general trend line. Matthew Hale, the 17th century jurist and commentator, also emphasized this distinction between judgments, which bind the parties in one case, and legal rules findable in precedent that do not bind in the same sense. Hale wrote that judgments bind as a law between the parties thereto, but judgments do not make a law properly so called because only the king and parliament can do that. So in other words, court decisions, they bind the parties, they obviously affect their legal rights and remedies, but they do not make legal rules like the ones that come from a legislature. Instead, as Hale put it, judicial decisions are just evidence of the law, not the law itself. Or consider Blackstone, whose commentaries are indispensable to understanding our Constitution's English foundations. He wrote that the true law and the opinion of the judge are not the same thing. Decisions that were absurd or unjust were not just bad law, they were not law in the first place. That is, they were outliers that fell far from the line of best fit and that established the legal rule. The New World followed these old world principles. Here, as in our mother country, each judgment bound the parties to a particular case, and hopefully those judgments were premised on a legal rule, a trend line that ran through the existing precedent. But individual judgments were at most evidence of the legal rule and not the legal rule itself, so parties were not strictly or legally bound by any particular decision from the past. So consider, for example, by way of illustration, Belt versus Belt. This is a 1771 case from Maryland. In that case, a colonial court gave quote unquote no credit to a recent on-point decision. Why? Because it was expressly contrary to several influential decisions by Lord Mansfield. This practice was common in the colonial era. Judges were not hamstrung by erroneous decisions from the past, even on the same or similar facts. Instead, they would look to a body of law on a given topic, and they would try to follow a trend. As the famous lawyer James Otis put it in 1761, it was better to observe the known principles of precedent than any one decision. On this point, the Federalists and the Anti-Federalists were united. So take, for example, my beloved Brutus. He remarked that judgments rendered in the new federal courts will immediately affect only individuals, so that it will be a series of determinations that will probably take place before the people will even be informed of them. That is, the applicable legal rules will not come from one decision, but from a precedential trend line over time. And as much as it just grieves me to credit Alexander Hamilton with anything, I would be remiss not to credit him with making this same point in Federalist 78. I'm sure you all remember one of the most famous lines in that paper, that is that federal judges would be bound down by strict rules and precedent. But you may not remember the full context of the sentence that Hamilton gave. Hamilton wrote, quote, "A voluminous code of laws is one of the inconveniences necessarily connected to a free government. To avoid an arbitrary discretion in the courts, it is indispensable that judges will be strictly bound down by laws and precedents. Very considerable bulk," Hamilton wrote, "and must demand long and laborious study to acquire a competent knowledge of them." Now, of course, if the judge's only job was to read a sentence in an opinion and then mechanistically apply it as binding law, that would not require study and it would not require skill. As Hamilton put it, however, the entire art of being a judge is to have sufficient skill in the law to discern patterns in the voluminous data points of legal authority. This history is critical to understanding the original meaning of the judicial power that's vested in Article 3. The judicial power derives from that common law tradition, from Hardwicke to Hale and from Brutus to Hamilton. So there is every reason to think that the judicial power is the power to find law in the scatterplot. It is not it is not the power to make law in a published penal opinion. This general law foundation of our judicial power can be seen in early Supreme Court practice. For the first decade or so of the Supreme Court's existence, the justices delivered their opinions seriatim. That is, each justice wrote a separate opinion. So for example, in Chisholm versus Georgia, Chief Justice Jay and Justices Blair, Wilson, and Cushing each delivered their own opinions explaining their reasons for supporting the judgment. Justice Iredell dissented. This practice meant that there was no single opinion for the court that would serve as precedent, at least not the way we understand it today. Instead, what mattered to the early jurists was the bottom line judgment, which in that case was that Alexander Chisholm could sue the state of Georgia in a federal court. Each justice's opinion was very important, but none of them purported to make or establish law. They simply explained how the various justices found the law. That is, the opinions were better or worse evidence of where the legal line was. And we quickly learned who was right and who was wrong, whose evidence was better and whose was worse, because almost immediately after Chisholm was decided, the people ratified the 11th Amendment, overturned Chisholm, and vindicated Justice Iredell. For present purposes, however, the important point is that every justice in Chisholm used the scatterplot model for finding law. So for example, Justice Wilson looked to a constellation of sources. He looked to the ancient Greek of Socrates, the 13th century jurist Henry de Bracton, the Spaniards of Aragon, and Frederick the Great. In other words, Wilson looked to a variety of different data points to find his trend line. His trend line was wrong, but he used the scatterplot nonetheless. And Justice Wilson's understanding of the scatterplot was commonplace at the founding. Judgments were evidence of the law along numerous other sources like Bracton. As Justice Wilson explained later in life, as to the parties in a case, judgments continue to be effective laws unless and until they are reversed. But in other parties' cases, the judgments could only be considered as strong evidence of the law. And thus it made perfect sense for him to look beyond legal precedent. Now, of course, the court no longer issues seriatim opinions or cites Frederick the Great with regularity. Instead, the practice of issuing seriatim opinions ended pretty quickly during the Marshall Court. Now, did the change from seriatim opinions to opinions for the court change the way that Americans thought about precedent? Emphatically, no, as evidenced by, among other things, Justice Story's opinion in Swift. That decision was issued during the Taney Court, and this is what Justice Story says in discussing how cases are merely evidence of the law. These are Justice Story's words. The decisions of courts are, at most, only evidence of what the laws are, and are not themselves laws. They are often re-examined, they are reversed, they are qualified by the courts themselves whenever they are found to be either defective or ill-founded or otherwise incorrect. Abraham Lincoln adopted this exact same view when he pushed back against Dred Scott. If the court could, in a single decision, these are Lincoln's words, irrevocably fix vital questions affecting the whole people, the people would have ceased to be their own rulers, having resigned their government into the hands of the Supreme Court. Thus, consistent with the scatterplot analogy, Lincoln viewed Dred Scott as an outlier. It was an aberration, a departure from the least squares line, and so it could not irrevocably change the law. Now compare that approach to the one that Stephen Douglas took when defending Dred Scott. For example, in his famous debates with Lincoln, Douglas declared the following: "The Constitution of the United States created the Supreme Court for the purpose of deciding all disputed questions touching the true construction of that instrument." End quote. To Douglas, such decisions were the law of the land binding on every good citizen. Now, Douglas was obviously wrong. Dred Scott obviously was not the true construction of the Constitution. It was wrong on its own terms, and it was proven wrong by, among other things, Lincoln's election, the Civil War, and the 14th Amendment. But Douglas's conception of precedent did emphatically take hold. From the 1850s until the 1950s, the meaning of precedent and its binding effect changed. It moved away from the general law model reflected in Swift and to the more law declaration model that's reflected in Dred Scott. As Justice Holmes put it in 1917, the law is not a brooding omnipresence in the sky. Rather, in Holmes's words, it is the articulate voice of some sovereign. Courts are the voices of the sovereign, Holmes argued, just as much as legislatures are. So when courts speak through their opinions, they are speaking with the sovereign force of law just as much as legislatures when they speak through the sovereign force of statutes, Holmes would say. By the time of the Warren Court, this law declaration model was in full swing, and it is the cornerstone of modern conceptions of judicial supremacy. As Professor Alexander Bickel described it, this way of thinking, whatever the court lays down is right, even if it's wrong, because the court and only the court speaks in the name of the Constitution. While Bickel and Herbert Wechsler and many other professors of the day lamented this approach, there is no denying that law declaration became one of the Supreme Court's most important functions. And every lawyer in this room was raised to believe, as Holmes did, that judges make case law, that case law is binding, and that law declaration is the reason that we smash the refresh button on SCOTUS blog every June like retirees playing the slots in Vegas. Now, the point of this lecture is not to lament judicial supremacy, though there is much to lament about it. Nor is the point to criticize the Supreme Court for the way that it navigated the Civil War or Reconstruction or the Civil Rights Amendment. The Civil Rights Movement. The Supreme Court is supreme, and it is our one and only constitutionally guaranteed court. So, its role in all things, including but not limited to precedent, differs from the role of the inferior federal courts. And one of the Supreme Court's most important roles is to review and impose order on the judicial system. But that is a question of vertical stare decisis, which is beyond the point of this lecture. Rather, my point is about horizontal stare decisis in the federal courts of appeal. And I have 3 takeaway points for you this evening. First, Justice Story and his approach to finding law was the one that predated and pervaded America's founding. Second, the Supreme Court eschewed Story's approach so that it could declare the law, but law declaration serves little or no purpose at all in the intermediate federal courts. Third, in the absence of any need, or perhaps even any power to declare the law in the inferior federal courts, query whether our rules to horizontal precedent would be better if we restored the Story-esque scatterplot that is so deeply rooted in our nation's history and tradition. Now, if I have convinced you so far that Story's scatterplot is at least potentially a good idea, and at least potentially for the intermediate courts of appeal, you might have some practical questions, and you may wonder why I am so exercised about this. And the answer is that it would change a lot about the way our courts of appeals operate today. In the interest of time, I'm going to limit myself to 2 enormous changes: the published versus unpublished opinion dichotomy and the rule of orderliness, or whatever your circuit calls the rule that one panel's opinion binds all future panels. So first things first, let's talk about opinion publication. As you all know, in the courts of appeal, opinions come in 2 varieties: published and unpublished. Published opinions are printed in the Federal Reporter, the fancy leather-bound books that we all have in our offices and look so good on our Zoom backgrounds. The unpublished opinions are not published anywhere, not in any book anyway. Our courts just post those sad, unloved opinions on our websites, and then the data crawlers from Lexis and Westlaw pick them up and put them into their databases. The logic behind this distinction goes as follows. A published opinion is binding precedent. Future panels are bound to follow it. So those belong in leather-bound books alongside the United States reports and the United States Code. An unpublished opinion, by contrast, is not binding. I mean, yes, it determines the rights and obligations of the parties to that case, but it does not apply to anyone else, including members of the public or future judges. Now, this distinction is hugely important in our circuit courts. Back when I was in law school, fully 9 circuits either prohibited litigants from even citing unpublished opinions, or they had rules affirmatively discouraging the practice. I can only imagine that Justice Story was turning in his grave. Was the idea that unpublished opinions are so subversive to the legal order that they must be thrown into Orwell's memory hole? I mean, gosh, if we allow people to even cite the unpublished opinions, some wayward federal judge would read them and unwittingly apply them? In 2006, the Supreme Court adopted FRAP 32.1, which deep-sixed this prohibition on citing unpublished decisions. But it remains true to this day in every circuit across the country, including mine, obviously, that unpublished opinions have 0 precedential value. Story's scatterplot would say balderdash. The overwhelming bulk of federal appellate work is done through unpublished opinions. From September 2023 until September of 2024, a staggering 85.6% of all opinions were unpublished. In every single one of those, the Court of Appeals rendered a judgment. Every single one of them reflected a solemn exercise of the federal judicial power. Every single one of them disposed of an Article III case or controversy. Every single one of them explained why a federal court chose to grant or deny relief. And every single one of them is better or worse evidence of a legal rule. For scatterplot purposes, it does not matter one whit whether the court decided to publish an opinion. No matter where or whether it is published, the opinion merely explains an appellate judgment. The opinion is a record of how a particular panel found the law and applied it in a case. And it applied and picked a new data point in the grand scatterplot of the relevant doctrine. And if you care about finding law, and I sure hope you do, wouldn't you care just as much about Plaintiff A winning in an unpublished case as you would about Plaintiff Z losing in a published one? Now, in finding the line of best fit through the scatterplot, every single judgment matters. So why would we pretend that 86% of the appellate decisions in our country simply do not exist? And in finding the line of best fit, it is the judgment, not the opinion, that counts. So why would we care whether the panel chose to publish its explanation or whether the panel even chose to write an explanation at all? For its part, the Supreme Court of the United States does not seem to care. In addition to banning the unpublished opinion citation practices in the FRAP, the Supreme Court has granted certiorari to review 48 unpublished decisions from 2018 to 2024. And the court reverses both published and unpublished decisions with equal aplomb. What's more, several high-profile court decisions in the last few decades have originated in unpublished Court of Appeals decisions, including Church of Lukumi Babuai, and one of my favorites from my clerk term, Ricci versus DeStefano. So if the Supreme Court does not appear to care about our publication practices, and if the publication decision is irrelevant to the scatterplot that defined the concept of precedent at the founding, you have to wonder what is really driving the publication fixation in the federal courts. Second, let's talk about the rule of orderliness, or the rule of panel precedent, or whatever your circuit calls it. This is what we generally think of as the horizontal stare decisis rule in the inferior federal courts, that one panel's decision will bind all future panels until it's overturned. Again, Justice Story would cry foul. If the words of the opinion were binding law, then judges would be making law like legislators, not finding it like Justice Story did. Their written word would bind subsequent litigants and jurists like the text of a statute. But if I can lay nothing else on your hearts tonight, I hope you will take home this. The word case law is every bit as big of a misnomer as substantive due process and green pastel redness. The Supreme Court has admonished us that we should not read their opinions like statutes. They have said that over and over. So why do intermediate appellate courts insist on reading their own work with such wooden, under-theorized literalism? Well, hold on, you might say. It's called the rule of orderliness for a reason. Namely, without it, there will be complete chaos. Panels will be doing all sorts of crazy nonsense if they are not strictly bound to do what a prior panel said. Now, this contention has always struck me as very odd. It's sort of like back during COVID when people were like turning on their televisions and looking for instructions on how long to Lysol their packages before they could bring them in from the garage, right? It was as if no one could figure out what to do with themselves unless and until an official gave them binding instructions on how to do it. But we don't normally think of federal judges this way. Rather, we trust judges to apply the law faithfully, even though interpretation is hard. I mean, is it easy to parse ERISA's preemption provision? Is it easy to understand the Medicaid regulations? Is it easy to research the original public meaning of the Second Amendment? Of course it's not. But we ask judges to do it anyway, and we don't normally act like the world is going to fall off its axis if a judge does not have a binding opinion to tell them what everything means. Now, maybe you think that, well, instead of having, more of if you think that we're going to have chaos in the absence of a binding panel opinion, ask yourself this: what is to control the first panel? I mean, after all, there's always going to be a first panel that makes some binding rule. So what if that panel is prone to error? Is the rule of orderliness really that orderly? If it makes all future panels replicate the first one's mistake? And wouldn't it be better, dare I say, more orderly, to just treat all decisions as data points and all outliers as, well, outliers? Now, perhaps less cynically, you think that the rule of orderliness promotes stability and even-handedness in the law. I mean, American judges, we wear black robes because, among other things, they symbolize uniformity. All of us are engaged in a singular, common pursuit to apply the law faithfully and without fear or favor. And you might reasonably see the rule of orderliness as part of that. It is an instrument of collegiality through which judges say to one another, I respect your decision because all judges are created equal. You made good law, and I will continue to treat it as good law until it's overturned. And the rule of orderliness says to the public, it does not matter if you had Judge Doe in 1975 or Judge Roe in 2025, you're going to get the same answer from every black-robed judge unless and until that case is overturned by the en banc court or the Supreme Court. Now, these noble views unquestionably form part of our nation's judicial tradition. But if anything, they undermine rather than justify the rule of orderliness, at least as it's currently understood. If all judges really are the same, then you do not need to bind any of them to do anything. You could trust them equally to look at the scatterplot and find the law. And if the law is as stable and as even-handed as you say it is, then finding the best fit line will be quite easy. By contrast, when you insist that earlier panel A binds later panel B, aren't you really saying that panel B is not equal, that it cannot be trusted, that it is unworthy of the collegiality that comes in the shared pursuit of finding the law, that precedent can be stable and uniform only through force and not through the story-esque inquiry that has defined the judicial function since the 16th century? If you think that panel B cannot be trusted in the absence of binding instructions, why do you think that panel B can be trusted to follow the binding instructions? And if the premise of the rule of orderliness is really a breakdown in trust between panels, haven't we lost even more than the scatterplot that undergirds Article 3? I will conclude with this. Will Rogers, the legendary cowboy and humorist, used to say that good judgment comes from experience, and a lot of experience comes from bad judgment. And he was quite right. A prior generation's bad judgment is not a straitjacket that prohibits future courts from finding the law correctly, nor does it prohibit future courts from learning where the real trend line runs and where the mistaken outliers lie. Rather, each new day brings new opportunities to learn and refine and improve. That is true in life, it is true in faith, and it is true in the law. Blackstone, Jay, and Story all understood this. It is woven into the fabric of Article 3, and the intermediate federal courts would do well to remember it. Thank you all very much.
You said, Andy.
Oh, that one. Oh, sorry.
So that was terrific. Let's begin with a few questions, and then I'll open it up for audience questions. So the first one is, so you have your frontal assault on the rule of orderliness. I'm wondering whether you've talked to any of your colleagues on the appellate bench and whether they are intrigued or whether they think you've fallen out of a tree and hit your head.
Yeah, I was confessing to my law clerks, I'm a little bit nervous about my colleagues' reaction to this talk, because, and I don't know, I hope that everyone here has some appreciation for how important this shibboleth is. Because it is something that I gave you the statistic of the 700 and some odd cases. We cite and apply this and talk about this with each other every single day, sometimes multiple times a day. And so I have talked about it with some of my colleagues, and the general reaction, without disclosing who said what, the general reaction that I've gotten is, that is really intriguing as a matter of original principle. Like, it's very difficult to debate, like, what happened between, say, the 16th century and the middle of the 19th century. But I think I've got a lot of raised eyebrows and concerns about the practical recommendations.
So let's explore that a little bit. I'm wondering, you talked about the stability of the law. I don't know whether your fellow judges just like saying, well, that rule seems pretty good to me and I'm bound by it, therefore it's easy for me to write an opinion. Or whether they're concerned about the stability in terms of litigants who appear before them. So sometimes, if you're a practicing businessman or people want to arrange their affairs, they'll sit there and say, look, I would sooner put up with a bad rule than to have one panel over here with one rule and another rule over there. A certain consistency will at least enable me to order my affairs accordingly. And wondering how that all fits into your thinking.
Yeah, so it's a very good question. And I'm not sure how much of this, like, the rule of orderliness does not really impact as much or doesn't bite as much in some of these areas of strict positive law, like statutory law, highly codified to bankruptcy. Those are kinds of things where the court will interpret the meaning of a particular provision, and we don't really get into like a rule of orderliness battle over those. Where it really gets into an actual battle is on more common law or general law or constitutional law sorts of questions, the ones that are naturally designed for judges to reason by analogy and to say, well, this case is a little bit more like that case or a little bit less like the other case, and so I'm going to follow this particular trend line. So I would think that in at least for most of the ones at least are coming to mind, where you would think, gosh, I really don't care what the right answer is. I just need to know. I need to have clarity so that I can then contract around it. Which is a big part of, I'm sure, for the DC lawyers in the room, a big part of the practice. I would think that most of that would be things that would either come from contractual stuff, which has relatively liquidated meanings, or statutory provisions like the bankruptcy code or something like that.
So sometimes, you'll see, you made a point about, well, can you trust judges to actually follow that rule of orderliness? And sometimes you'll get, in some areas of law, qualified immunity immediately comes to mind, where you'll get judges who will, they know that they have to follow a particular rule about what is clearly established law, et cetera. But then they will come up with what seem to be sometimes trivial facts to distinguish this case from another case. And I'm wondering whether if your fellow jurists adopted your scatterplot way of approaching cases, whether that would minimize that and people would get less angry focusing on, well, it shouldn't make any difference whether the person was kneeling or standing in terms of a result, and instead you could have a real argument about what's really going on, which is an argument about law.
Yeah, that might be right. I mean, I think we absolutely, I think one of the reasons I wanted to talk about this tonight and to put this into the public for discourse is that I think we already, and perhaps unthinkingly, tolerate a lot of this, and qualified immunity perhaps is a good example. And so, if you talk to a law clerk or you talk to a federal judge about qualified immunity, people often say, oh, it's such a fact-bound doctrine. And I suppose that's true, right? I mean, if you read two qualified immunity cases from the same court, sometimes from the same panel, and they come up with different answers, and you think, how did it really matter if they were kneeling or standing or the car was red or blue? Like these kinds of factual distinctions. Well, the answer is that we don't seem to be as strictly bound down by precedent in those cases already, right? And so if you have a panel that says, that, oh, it really matters if there was a high-speed chase, or it really matters if there was a weapon or deadly force used or whatever, that doesn't necessarily predict the answer in the next case, and we all seem to be somewhat okay with that. We have all sorts of criticisms about qualified immunity in other areas, obviously, but this is not one that seems to be on the leaderboard of what it is that we'd like to talk about. And so I guess part of my point is we already tolerate this. We already recognize that this goes into the judicial function in many important ways. And so I think the real question is, why is that, and what can we learn from it?
Well, in fact, you make the point that we tolerate it in kind of a fake way, which is to sit there and say, we're going to talk about how you can manipulate the facts and say, well, this happened on a Monday morning, this happened on a Tuesday afternoon, in order to reach the result that you want to reach, because you can't talk about it in terms of whether you agree with the law or disagree with the law. So I'm curious, one criticism I think you would get, which is to say, well, okay, if you can have one panel come out with one result and you don't like that result, all right, tomorrow's another day, you can come up with a different panel, maybe get a better draw and come up with a different result on the exact same legal issue, that's going to cause all kinds of confusion. You're going to end up having a lot more en banc decisions in order to resolve these ambiguities and differences. And I'm wondering whether you would agree that would be a necessary byproduct of your approach.
Yeah, so let me try to unpack, because I think there's actually two questions, if you will indulge me, kind of baked in there. One question is well, aren't we already, judges are just doing this sort of, whether it's disingenuous or bad faith or motivated reasoning or whatever, that's just bad judging, right? That's not, if motivated reasoning is bad judging regardless of whether it's done this way or another way or in qualified immunity cases or whatever. And so if the question is how do we get rid of motivated judging, right? I mean, this is as old as the Anti-Federalists' objections to Article 3. And so it's that's sort of baked into all of it, and I'm not sure that this really addresses that any more than any other sort of remedy or thought about Article 3 reforms would. So motivated reasoning is sort of a thing that I try to kind of cabin, because one of my thoughts is if we really trust federal judges to find law, which we should, and we always have, then we should trust them to do it accurately and in good faith and in accordance with the oath. So that's kind of one idea. But then the second point about en banc, you're totally right that there's a huge interaction between this and en banc proceedings. But I'm not really sure that it necessarily would require more en banc proceedings. I mean, one of the things, if you talk to federal judges across the country, now I realize also that the Fifth Circuit may have more en banc proceedings than, certainly more than the DC Circuit does, but it may have more than a lot of other circuits. But if you talk to judges about en banc proceedings, one of the things that's motivating it is panel A comes up with legal rule X, and the majority of the court doesn't like legal rule X. And so if you're in a world where legal rule X is going to be binding on all of us, it makes some sense that we would have an en banc vote as to whether we want to go with that or not go with that. Whereas if you weren't so strictly bound by what panel A said, maybe it would actually have the opposite effect, and you'd have fewer en banc proceedings because the panels would all be able to work together in a way to define law in the next case and not feel so strictly bound by every jot, tittle, and footnote in every single opinion written by every panel.
Do you think that this would, though, perhaps spur additional litigation because you take much more of an attitude of saying, well, okay, that was a bad panel decision, but tomorrow's another day and I'm going to have a different panel and forget what the first panel did. I may come up with a totally different result.
Yeah, and I think this is a valid criticism because one of the things that is absolutely baked into law and the notion of the scales of justice is that like cases should be treated alike. And so why would it be, even if it's an outlier judgment, why would it be, I don't mean to rephrase the question if but if there is an outlier judgment in the case of X versus Y and my facts are materially indistinguishable, why would I get a different answer just because the panel thought, oh, that's an outlier? Well, the answer to that is that if the outlier judgment really is a mistake, and you have to trust the federal court is going to be able to discern when it's motivated reasoning versus a genuine legal mistake, I would like to think that we would all agree that it would be better not to replicate the mistake than to sort of change the law by dint of repetition, because that is one of the things that is baked into the rule of orderliness is that one panel says something. Right? And the Supreme Court is granting however many 40, 50 cases a year. So if a federal court of appeals is saying it, that's going to be the answer for the overwhelming bulk of us, right? And who are living as Americans in this country. And so if the panel comes up with the rule and says, we think it's X, that is just going to get repeated over and over and over again until it becomes almost a self-fulfilling prophecy that is in fact the law, even if it was mistaken. And it becomes really, really difficult to change. And so that's part of what I'm kind of trying to caution against in this talk.
So we have a few minutes left. Already hands are going up. Just wait until you get a microphone. Identify who you are. Keep it short. End it with a question mark. Let's go over here. So,
is that Ed?
Yeah. Pass the microphone down. Or either way.
Ed Whalen, Ethics and Public Policy Center. Thanks, Judge, for your excellent talk. I wonder whether Panel A, to use your term, has a temptation to write far more broadly than it otherwise would, address all sorts of tangential issues precisely because of the rule of orderliness. I'd be interested whether you've seen or sensed that in action.
Yeah, so I would answer that. Thanks, Ed. It's great to see you, and I appreciate the question. I'd answer it in two different ways. Number one, yes, I think the rule of orderliness would naturally incentivize that sort of response and conduct, because if it really is a tabula rasa, why not just go ahead and do the thing, right? Let's answer a bunch of questions. But I think the corollary to the question, which is a really important one, is why is that? What is motivating Panel A in this hypothesis to do that very thing? And if the answer is to make rules that are going to govern future cases, that is deeply inconsistent with the way federal judges behaved and the way the way judges generally behave before we even had the federal judiciary in the history that comes up to Article 3 of the Constitution. So it's the impulse, what exactly is driving that to make federal judges feel this desire to make the rules that I think is one that's worth meditation.
That's interesting. So if it's going to end up being binding, you're tempted to be expansive rather than sitting there and saying, let's just answer this question.
Exactly right.
Leave it for tomorrow. Will be another scatter plot somewhere else.
Exactly right.
All right, let's go. Did you come here to John?
John Vecchione, New Civil Liberties Alliance. It strikes me this experiment has been done. There are many practitioners who believe in the Ninth Circuit. Even if a panel did not sit on the en banc panel, they do not follow the en banc rule. And so it strikes me, and then the Fifth Circuit and the Second Circuit, in my view, have very strong orderliness. They do not differ if they can avoid it. And I would think that most practitioners and people who want to govern their their activities and what they're doing prefer the 5th and the 2nd to the 9th because they don't know what they're getting. Have you had any cause to look into how the different circuits have worked under kind of different rules?
Yeah, I appreciate the question, and it's a fair, this is a very fair concern, and it's one that I can completely, this is what I meant by the sort of like, oh gosh, there's going to be chaos if we don't have this very strict rule of orderliness. And I guess I would answer the question in a couple points, which is, number one, to answer directly the empirical question, I haven't really studied, I'm not exactly sure how one would study, because some of this is going to be a little bit subjective as to whether you think the panel was in fact faithfully applying or whatever, and perhaps an empiricist will give us a law review article on that at some point. But if I just grant the premise, like in the Ninth Circuit perhaps, that the rule of orderliness is a slightly less prevailing norm, as you say, than perhaps in the 5th or the 2nd, is that good or bad? Well, I can understand from a litigator's perspective that I could see both sides of that argument. From on the one side, maybe it's great to just have an answer, unless the answer's against you. And then the question is, if the answer's against you and you just happen to draw a panel that either misidentified the law or put the judgment at the wrong spot on the scatterplot, why would it necessarily be that the only way to fix that is to go through the en banc procedures or through Supreme Court petitions for certiorari? Because, as you know, we do thousands of cases a year in the Fifth Circuit. We do, I don't know, a dozen or so, maybe in a busy year, en banc cases, and the court takes 40 or 50. So that means the overwhelming bulk of people are just going to have to live with the rules that they get. And the other point that I would just caution against, especially for the advocates like you, is that there is a huge interaction between all of the stuff that I'm discussing here tonight and party presentation. And I would ask you it this way: why in the world? Suppose that in case A, right, that it's a small local practitioner, does not have the New Civil Liberties Alliance to represent them, and they go through, they make their arguments, and they lose, right? And the arguments aren't that good, the factual development isn't that good, there's a bunch of stuff that's forfeited or waived, and it just, and the case comes out against them. And then party B comes up and hires you, right, or hires one of the other eminent lawyers in the room, and they have to come in and where you're not allowed to make your arguments because there's a binding precedent that goes against you. I've never quite understood why that would be true. Because if you have a client and you have a new case or controversy and it's not about necessarily picking panels and having panels do it differently. Some of this goes to the fact that it's your clients and the way that you choose to litigate your case. And why wouldn't it be that you should have a chance to have a judge think about your arguments afresh without the burden of saying that you've lost even before you started?
Yeah, it's certainly true that there's no horizontal rule of orderliness at the district court level, and the world as we know it hasn't collapsed.
That's a very good, that's also true.
Andrew, back there.
Thanks, John. You actually just kind of took it out of my mouth which is maybe I'll ask it a different way then. So what's the role of the Supreme Court in this? Is it more vertical? Is it more horizontal? And then what do the district courts do kind of on this layered scale?
Yeah, so let me take the second part first. The district courts, John's exactly right. The district courts their opinions don't bind themselves. Like the Western District of Texas doesn't bind the Western District of Texas. One judge in the Western District of Texas doesn't bind that judge in the Western District of Texas, and certainly doesn't bind the Eastern, Northern, Southern. And so it doesn't seem like the world is ending, right? There may be other criticisms of the way that the district courts are behaving, but that's not necessarily one of them. So that's point one. And then as to the Supreme Court, I see that as completely, that's a different question on at least two different dimensions. So as I pointed out in the talk, law declaration has been an essential part of what the Supreme Court has done for over a century. And that has its own reasons for it, and it has its own consequences from it. And that doesn't have, I guess really my own point is that the overwhelming bulk of legal work in this country is done in the inferior federal courts that really doesn't have that role, couldn't have that role, will never have that role. And so it's not obvious to me why we use law declaration as an excuse to not do a scatterplot in the inferior federal courts, the way I would get at it.
So we had Devin over here.
Is there a certain fairness aspect at it from the plaintiff's point of view, in that if they're going into a case where there is a bad panel opinion that they think is wrong, they're going to lose in the district court, they're going to lose in the Court of Appeals, and then when they go en banc or certiorari, there's lots of reasons not to grant that have nothing to do with the merits.
Right.
And so they may not have ever any judge consider their arguments that may be the best arguments why that panel opinion is wrong and they're right on the law.
Yeah. No, that's exactly what I was getting at in this earlier question, right? Is that, different plaintiffs have different arguments, different resources, different, legal equities, any number of different things, and we tend to gloss over those. A really hard rule of orderliness makes that irrelevant, and it doesn't matter if you've, hired the fanciest lawyer in Washington, D.C., or if you've got the best legal arguments, the best factual development. I mean, when we really start applying the rule of orderliness strongly, we start applying the same rules at 12b-6 and at Rule 56 that we would apply post-judgment, right? And so at that point, why are we even having trials and things, right? The factual development is not relevant, right? Because we're answering the legal questions once and for all in the same way that Congress would. And that is a very anti-plaintiff, or I'm not sure you would think of it necessarily as anti-plaintiff, but it's like anti-new case, right? It just means that we're answering a question for all time without any regard for the fact that a new case has a new fact and an opportunity to refine and come up with a different answer.
Take one more question. We'll go here with John.
John Eastman, how are you, Judge?
Yeah, very good.
One of the things underlying Justice Story's opinion in Swift is, of course, the idea that there is a natural principle of justice to be found. Holmes takes that out in his book on the common law, and we've largely accepted that there is no such thing as natural principles of justice. How do we get to where you want to be without resurrecting the notion that there is natural principles of justice that judges can find?
But it's a great question. Thank you, John. And they are related, but I don't think they're necessarily the same, right? So the example that I gave from Chisholm, right? Those aren't necessarily legal principles that are natural principles of justice, but they are very much legal data points that are relevant to understanding how sovereign immunity should work in federal court or should not, as the case may be. And so I think one of the important things to do is to at least start with a recognition that if judges aren't making law the way Holmes very much thought that we were, right? I mean, that is the whole premise of his approach to the common law, was that when the state court says that the rule of contributory negligence is X, that is it doesn't matter if that's in a Supreme Court opinion or it's in a state statute. That was his one of his core insights. Is if we can reject that and recognize the fact that we're not making rules, instead we're trying to find them. I think that goes a long way to helping us better understand both what federal judges are supposed to be doing and also our understanding of the nature of law.
Well, this has been, as I knew it would be, absolutely terrific. Judge, we have some parting gifts for you.
Oh.
We have a complete set of Story's commentaries, and then we have the Cliff Notes version, if you will,
Oh, that's great.
An abridged version. And most importantly, we have for you here our Defender of the Constitution.
Amazing.
For which you richly deserve.
Amazing.
Please
Thank you
join
so
me in
much.
thanking Judge Andrew Oldham.
Thank you. That is great.
For a reception outside. We'll send these all back to your
Oh,
chambers.
thank
You do not have to.